You may be seated. Thank you. Ladies and gentlemen, I apologize. We took longer than I had anticipated it would take. I believe we are ready for your cross-examination, Ms. Branstad. Deputy, I would remind you, you are still under oath.
Yes, sir.
Lieutenant Bigaouette, let's just clarify a few things. In the June 22nd video, at 9:25 p.m., Jason Carter is talking with Jason Sandholt. Is that correct?
I believe, well, I don't know the exact time. I wasn't paying that close attention, but I hear his voice towards the, I would say probably the last 45 minutes of that interview. I think the interview concluded around 10 p.m. and the last 45 minutes or so were between Jason Carter and Jason Sandholt.
Now, during that course of that interview, Jason Carter agreed to voluntarily hand over his phone.
May I ask, which phone?
Actually, both phones.
Well, it was my understanding he had already voluntarily delivered it to the sheriff's office prior to that interview, that morning.
And he was questioned about what the password was, and he showed the officer how to open his phone.
Just for clarification, are you talking about the flip phone?
The flip phone didn't need a password, did it?
Correct. That's my understanding.
And the other phone didn't need a password either, but Jason Carter showed the officer how to open the phone.
There was discussion on his phone where he signed a release form on the 19th of June. Am I misunderstanding your question? I'm sorry.
And then on the 22nd, the officer asked him how to open it. Is that correct?
I thought that conversation, typically, I've seen those forms before, and usually when on the, what I'm referring to, the form they discuss, in the interview I took part in on the 19th, afternoon of the 19th of June, that's typically a question, how do you sometimes they're swipes, sometimes they're a number pad, that's discussed there.
And perhaps I'm remembering it incorrectly, maybe it was both times, but Jason Carter did show how to open his phone.
On the 22nd, I'm sorry.
At any time that he was asked, he voluntarily handed over his phone and showed how to open it.
I know on the 19th that was done, or he did. On the 22nd, I would have to review that portion of a video again to give you a confident or for sure answer.
And that video on the 22nd stretches over about 9 hours.
Approximately, yes.
During that entire time, Jason Carter's seated in the same chair.
Yes.
Now, you heard there were some questions that were played about time. At some point during that interview, one of the officers told Jason Carter, do your best, we're not going to hold you to the minute.
I believe, I remember hearing that comment with Agent Dave Overton on the 19th of June at the Pleasantville Police Department, an audio clip. Is where I recall hearing that. I'm not saying it could have been repeated in a different interview, but that's, when you say that phrase, that's where I remember that phrase being mentioned.
And there are a few times during the course of these multiple interviews where Jason is told, just give us your best guess.
That's possible, yes.
Law enforcement techniques in interviews and interrogations allow officers to lie to the individual to whom they're speaking.
Yes.
To be aggressive.
Confrontational, nothing physical by any means.
To play what we've all seen on television, the good cop, bad cop.
Okay.
Is that true?
Yes.
And the clips you showed sometimes would go back and forth between what order they were in. So if we saw 4 clips from June 19th, because those weren't time-stamped, they weren't necessarily in chronological order, correct?
No, like I mentioned, sometimes the conversation would go overlapping. So there was back and forth between video clips.
Now, let me just transition a little bit. You've worked on this case other than just reviewing these videos.
In the onset, yes.
You received multiple reports about a suspicious white truck in the area of 132 Perry Street, Lacona, Iowa.
Yes, I believe there was 2 or 3.
A report from Brenda Johnson. Do you recall that?
Is she the one, I believe, on Highway S45? Yes.
And a report from Susan Wolf.
Can I review my, I think I have the same notes you do.
Yes.
Yes.
A report from Charles Park.
Yes.
Let me also clarify, you received another report about someone with an empty stroller, not containing a baby, walking on the gravel, scruffy, wearing a ball cap, who looked out of place to one of the neighbors.
I believe that was observed on June 17th by a neighbor to the west of Bill and Shirley Carter's residence.
Now, you also received many, many reports implicating Joel Followell, John Followell, Joe Sedlock, and Callie Shin, didn't you?
To say I received complaints, just to clarify, I guess, your question, the other instance we were talking about, I guess, with the trucks, or what somebody said, came into an initial report to go look at. As far as those trucks you mentioned on, and the gentleman with the stroller, things like that, I would speak with those individuals if I could locate them and report that information back. As far as reports of, I've heard the names that you've mentioned, the Followells and Sedlocks. I'm familiar with those people. I've heard those names, but I have not taken a report, an investigating report specifically on those people.
Well, I understand that you may have been more directly involved with the suspicious white truck, but let me talk. You are well aware that the Marion County Sheriff's Department received many reports implicating John Followell, Joel Followell, Joe Sedlock, and Callie Shin with regard to the Shirley Carter homicide.
Your Honor, objection beyond the scope of the direct.
Overruled. You may answer, sir.
Thank you. I know Detective Caius has followed up on many information coming in.
And that's sort of a different question, but you're aware that there were many reports implicating those 4 people, correct?
Correct.
Do you know if Brenda Johnson, David Johnson, Charles Park, or Susan Wolf were ever provided photographs of any of those people to compare with the people that they saw?
I don't believe so.
I have no further questions.
Any redirect?
Yes, Your Honor. As it relates to Brenda Johnson, for example, you were the individual who was aware of that. You were the person who was aware of that that tip saying we saw a white pickup truck. Is that a fair statement?
Correct.
Just so we all understand, S45 is the main road that runs south of the Y to Melcher, Dallas, is it not?
Correct. Connecting the towns of Pleasantville and Melcher.
Sir, how many white pickup trucks are there in Marion County, Iowa, if you know?
There are multiple. I have no idea the number.
In addition to that, on the day of June 19, 2015, did Deputy Jake Smith participate in the investigation of Shirley Carter?
Yes, he did.
Was he the task force officer at the time, meaning Marion County Sheriff's Office's representative to the mine task force?
Correct.
Could you tell the jury what vehicle was his unmarked vehicle on June 19, 2015?
He had an unmarked, I don't know the year, it was an unmarked white Chevy pickup truck.
And he responded to the scene in his white pickup truck.
Correct.
As it relates to the stroller that was observed, did the Marion County Sheriff's Department, in fact, determine who that individual was?
I did not. I don't know if anybody else was able to.
Are you aware of whether or not the Marion County Sheriff's Department, in fact, talked to a woman with the last name of Friday who had contact? If you know. If you don't, I understand.
I did not, I don't believe, but I don't recall if anybody else did.
And Ms. Branstad mentioned a number of other individuals' names. Isn't it true, or if you know, did the Marion County Sheriff's Department put Detective Reed Caius to investigate each and every one of those leads?
Yes.
Was that the directive of the sheriff was to spend how much time, whatever it took, to run down those leads?
That was my understanding, yes.
You work with Detective Caius, do you not?
Yes,
You see him?
correct.
Has that been his primary focus for the last year?
Objection, calls for speculation.
Witness may answer if he knows.
He has made many comments directly to me that a large portion of his time has,
I'm going to stop you
I'm sorry.
about any comments that were made.
okay.
Sir, just based on what you know, has that been his primary responsibility at the Sheriff's Department for the past year?
Yeah.
Objection, Your Honor. May I voir dire the witness for my objection?
You may.
Is there any way you would know other than the statements of Detective Caius?
Just observing him when we cross paths in the office, I mean, what he's working on today, what I'm working on, and
And those are what he tells you?
yes,
Your Honor, same objection as to hearsay and speculation.
Your Honor, may I respond?
Sustained.
Sir, have you witnessed Detective Caius working on this case?
yes,
And what he was tasked to do by the sheriff?
Objection, calls for hearsay.
Sustained.
Your Honor, may we approach?
You may.
Lieutenant, on June 19, 2015, did you conduct an interview instead of an interrogation with Jason Carter?
interview,
And so was that an opportunity for him to tell you what he knew about his mother's death?
correct.
Did he ever tell you on June 19, 2015, he had a second phone?
No,
Did he ever tell you that at any point he left the home to place the second phone in his truck?
can you say the question again, I'm sorry.
Did he ever alert you that he left the home to place his second phone in the truck?
No,
Did he ever explain that he ever left the home at any time on June 19, 2015?
no, other than maybe to wave down ambulance or law enforcement.
You were asked questions about June 22nd, that Jason Carter provided his second phone at that time. Are you aware of how it was that Jason Carter came to provide that phone to law enforcement?
Yes,
And, sir, are you aware of whether or not law enforcement seized that phone from Jason Carter immediately?
from the audio that I reviewed, Jason Carter explains that he drove the phone, retrieved the phone from his residence under the hood, drove it to the sheriff's office, was let in, waited voluntarily in the lobby, and I believe it was Deputy Lane that came out, and he provided the phone voluntarily to Deputy Lane.
So if there's any assertion that law enforcement saw Mr. Carter open the hood and see whether or not where the phone or spent shell casings could or could not have been, that's not what occurred, was it?
On that date?
Yes.
Or any date, no.
Okay. Nothing further. Pass the witness back.
Further cross-examination?
The officer certainly could have walked out with Jason Carter and looked under the hood at the time that Jason went to get the phone, couldn't he?
When he brought it to the sheriff's office?
Yes.
It was my understanding, I think I may be inaccurate, but I thought he drove a different vehicle to the office.
He went and got the phone out of his vehicle, correct?
I believe there was a comment about driving a white Dakota from his father's residence home to get it. But he left his father's residence, 132 Perry Street, on the morning of June 22nd, went to his house, said he was going to retrieve the phone from inside the engine compartment of that vehicle and bring it to the sheriff's office.
And he revealed the minute he was asked about the phone where that phone was, didn't he?
Yes.
And on June 19th, Jason Carter wasn't asked if he had a second phone, was he?
No.
And then let me just clarify 3 small things. Other than a rifle could fit under the hood of the vehicle, there is no evidence that there was ever any rifle under the hood of Jason Carter's vehicle, is there?
Not that I've been provided.
And the lead detectives in this case are Reed Caius and Mark Ludwig, correct?
They've spent the primary majority of their time on this case, yes.
And they're designated as the lead detectives for this.
It's my understanding, yes.
And then just one minor point, because of the fold of the shirt, Jason Carter's shirt says Duck Connection. It does not have a profanity on it, does it?
Oh, no, I thought it said Ducks Unlimited. I couldn't tell either because it's like a circle or...
I have no further questions.
Anything further, Mr. Bull?
No, sir.
Thank you, sir. You may step down. May this witness be excused?
On behalf of the state, yes.
Yes, Your Honor.
You are excused. Thank you very much.
Thank you, sir.
Further evidence or testimony on behalf of the state?
The state of Iowa rests.
Very well. Ladies and gentlemen, I think I indicated to you yesterday that I thought the state might rest today. I do not believe that we are going to have time to start evidence or testimony on behalf of the defendant, assuming he presents such evidence or testimony this afternoon. So we are going to be at recess until Monday morning at 9 a.m. You have a long weekend. I kind of gave you the little pep talk yesterday. It's been a long haul. It is absolutely critical that you make your decisions based only on evidence and testimony that you hear in this courtroom. It is absolutely crucial that you not discuss the significance of evidence and testimony that you've heard in this courtroom until you get back to the jury room and begin your deliberations. So it's not appropriate to talk about this case with anyone between now and Monday morning at 9 o'clock. Please keep an open mind. You have not necessarily heard all of the evidence. Please do not discuss it with anyone. Please do not allow yourself to be exposed to or let anyone tell you about any media reports that might be occurring related to this case. Go out, enjoy the sunshine, have a nice relaxing weekend. We'll see you on Monday morning at 9. Why don't we take a short break? Do you want to make a record this afternoon?
Yes, Your Honor.
Okay. Let's take 10 minutes, 15 minutes. Okay?
Did disconnect.
Okay, we ready to make whatever record you want to make?
May I approach, Your Honor?
You may.
Your Honor, as was stated in chambers earlier, the state provided the defense with the emails from Agent Mark Ludwig. Last night, we reviewed the emails of Agent Ludwig, and many exhibits have been placed in front of the court. All of them court's exhibits offered in support of the motion to dismiss. And Your Honor, at this point, we are renewing our motion to dismiss. And Your Honor, I think that we have just provided exhibits K through AP, slightly out of order, but Your Honor, may I address the renewed motion to dismiss before I address our motion for a judgment of acquittal?
You may.
Your Honor, I think the court's well aware of the initial grounds for the motion to dismiss. At that time, the court's ruling certainly indicated that there was a need for additional proof in front of the court, first to actual prejudice and to bias. And Your Honor, I think one of the things to show prejudice is an intentional attempt to gain tactical advantage. And Your Honor, that's citing Wagner, which is at 410 Northwest 2nd, 207. And also looking at Brown, which states where evidence is material and where there's the unavoidable possibility that the evidence might be significantly favorable to the accused, denial of access to the evidence is a violation of due process. That's citing Brown, which is at 337 Northwest 2nd. Your Honor, the evidence that is in the following exhibits to support the arguments show unreasonable delay, actual prejudice, lack of investigation, collusion between the law enforcement and the plaintiffs in a civil suit. And Your Honor, we'll cite some of the specific references. Certainly the bias is also shown. Your Honor, I'll start with Exhibit AN, which is an email indicating that there were unrecorded conversations between law enforcement and Bill Carter's civil trial attorneys, as well as reports with witnesses that were not preserved. Your Honor, if we move, then just the next few exhibits just generally show, I think, the mindset with regard to Agent Ludwig. There's Exhibit AO, which is an email indicating Agent Ludwig's plan to bring Bill Carter to Chase Carter's football practice. At that point, I think Agent Ludwig knew it was an attempt to antagonize Jason Carter. Exhibit AP is an email in which Agent Ludwig discusses his belief that Jason Carter is hoping his father will expire and delaying trial for that reason. That Exhibit K is just a statement that Jason Carter isn't a nice guy, and Exhibit AH is an email from Agent Ludwig talking about his desire to put the first set of handcuffs on Jason Carter. More importantly, though, we look at the next exhibits which deal with the failure to follow up on leads and evidence. There's Exhibit L, which is an email from Detective Caius, indicating people who still needed to be interviewed, many of whom still are not interviewed. Exhibit M is an email from Michael Motzinger to Agent Ludwig with the direction to prepare what DCI has done to rule Bill out and support certain financial statements made by Bill. And it should be noted that this is dated April 4th, 2016. Those statements are now, through this trial and other testimony, demonstrably false. Exhibit N are emails with Agent Ludwig stating that information on Joel Followell was not shared with Detective Caius, and then stating that it's an unlikely connection with the homicide. Your Honor, no matter what that opinion was, I believe this is a Brady violation because we still don't have the background search DCI provided on these people or that information. Exhibit O deals with an email with Detective Murillo about the seizure of the rifle that could not be ruled out as a murder weapon. That is a minor point, but that was information that wasn't provided to the defense exactly in that way. But there's also Exhibit P, which is a 2015 email from Officer Halverson to Agent Ludwig asking for fingerprints of Ray Bertrand. To my knowledge, that wasn't followed. Now we get to the real, sort of the heart of what we're asking. Your Honor, at first I'd ask that the court take judicial notice of the trial scheduling order entered by the court in civil trial LACV 095809. That was a March 10th, 2016 order. And Your Honor, that's because that's the point at which witness sequestration was ordered in that case. And when was it? I'm sorry, Your Honor, it was the last pretrial when sequestration was ordered, but I'll get to that. But Exhibit Q is the email from Agent Ludwig indicating a plan to arrest Jason Carter on March 25th and providing a media release. And then there's a following email stating that the arrest was not going to take place as planned. Your Honor, Exhibit S is where we get into the heart of this. There was a sequestration order in that case prior to Agent Ludwig's testimony and while he was still subject to recall. He is requesting video from the Carter trial in Exhibit S. He then testifies, I believe it was on December 12th, 2017. He was still subject to recall, and at that point, he's still sending out emails, trying to get copies of the testimony. I will point out, and Your Honor, let me just ask that you take judicial notice of the sequestration from the final pre-trial on November 20th, 2017. It's page 11 and 13 of the transcript.
And that's, you're talking about the transcript from the civil trial?
Yes, LACV 095809.
Okay.
Agent Ludwig's emails talk about when Jason Carter's going to testify, the date he's expected to testify, and a plan to arrest him either following testimony or following the verdict. Additionally, one of Agent Ludwig's emails talks specifically about what happened in the courtroom and says they did us a favor by pointing at Bill Carter. This will help out in the criminal trial. Agent Ludwig thinks it's prejudice at that point. Agent Ludwig in Exhibit U, while the trial's still going on, indicates that there's a possible flurry of activity following the civil trial. I think that's referencing the arrest. But most importantly, Trooper Thorup testified that Agent Ludwig kept him up to date on what was going on and who was testifying during the civil trial while he's under this sequestration.
And both were designated witnesses in that case?
Agent Ludwig was, and he's the one who's finding out what's going on and providing information to Trooper Thorup. Your Honor, then if we look at the potential Brady violations here, there is Exhibit V, which is a September 28th, 2015 email from Lieutenant Bigaouette to Agent Ludwig that has handwritten notes from the first responders who testified. including a statement from Kurt Seddon, who now says that he was certain Jason Carter made the statements about the 2 holes. The handwritten notes of that indicate a B/J, which I'm going to assume means Bill or Jason. There are statements from Lori Goff, from Jason Ford, and from Zach Kalvig, all memorialized in notes that were never provided to the defense. And Your Honor, these are exculpatory statements. Exhibit W is an email chain including a March 4th, 2016 email. And this one probably was the most surprising to me because Agent Ludwig was asked about cell tower information. The state put on a cell tower expert. Agent Ludwig says, well, standing at 132 Perry Street, they hit on 5 different cell towers. We have someone who testified there are only 2 cell towers that provided coverage. And there may be explanation to it. That's certainly exculpatory evidence that should have been available to the defendant. There are no reports about this, and this was never disclosed by Agent Ludwig or anyone. Exhibit J is an email from,
No, it's not Jay.
oh, someone's good. Well, since, let me look. No, hold on. What? Your Honor, I'm sorry, that's AO now, is an email from Detective Caius to Detective Ludwig stating that the Marion County Sheriff's Office does not have capacity. And I think,
AO is the email dealing with Mark Ludwig taking Bill Carter to Chase's football practice.
Your Honor, let me find what this is. Here we go. Your Honor, I will come back to that one. Exhibit X is an email from Agent Ludwig in December of 2018, indicating that he had to add multiple more exhibits on the case. Again, I would just say that the defendant was not provided information that that was upcoming. Exhibit Y are previously unknown reports of Michael Motzinger containing arguably exculpatory information relating to the time period during which Jason Carter communicated knowledge of the missing rifle. And Your Honor, what I'm talking about is, this is a report from Michael Motzinger saying, Jason Carter contacted us at this time to report that this rifle was not on the search warrant. Your Honor, that report, had it been known, may have contradicted Jason Sandholt's testimony that there was a call Sunday morning on Father's Day, I believe it was the 22nd, indicating that he was concerned about the rifle. And Your Honor, I would also note that Agent Ludwig's most recent report, case summary, indicates that it was in the afternoon when the family got together that report was made. Exhibit Z is an email from Mark Ludwig detailing a July 13th, 2018 report by Michelle Daniels providing evidence of other suspects. This report has not been received by the defense. Exhibit AA is an email with Mark Ludwig seeking emails deleted by Marion County Detective Caius, which references other leads and suspects in the case. And, Your Honor, I would say if these were missing or deleted emails, the defense should have been aware of that there were missing leads or suspects, or what was believed to be within those. At this point, we don't know what's missing. Because, Your Honor, that would be cross-examination information for the detective. That's under Brady as well. Exhibit AB is an email between Detective Caius and Agent Ludwig talking about a lead from Pat Anderson. That has not been disclosed to the defense. Exhibit AC is an email from Detective Caius to Agent Ludwig with information provided from Todd Farver to the Marion County Sheriff regarding the location of the murder weapon. Your Honor, this is a crucial one also. This is dated June 6th, 2016. The main reason that we've done this writ and been calling Todd Farver is because Todd Farver provided information to the defense that he made this report in June of, well, it didn't say June, but in 2016. We didn't have a report that indicated that that was the time when that was made. It was followed up, we do have a much later report. And I will point out, we didn't find out about Todd Farver's information provided to law enforcement in this case until Todd Farver contacted our office to say he'd made that report. That was December 2018. Exhibit AD is an email between Detective Caius and Agent Ludwig referencing a Marlboro man and a cousin of Jason Carter. Your Honor, I will say that this reference sounds slightly familiar, but I don't know if we have a report on this. We certainly don't know if there was any follow-up. Exhibit AE is an April 16, 2016 email with Agent Ludwig identifying Angela Johnson as a person with information about names where the weapon is. This information was never turned over to the defense, and Angela Johnson's name is new to us as of last night. Exhibit AF is a November 2015 email between Agent Ludwig and Detective Caius, where Agent Ludwig specifically directs Detective Caius not to follow up on a witness with probable exculpatory information. That witness is Jeremiah Laird, who is now deceased and unavailable to be investigated. And Your Honor, I point to the apparent bias with Agent Ludwig, who is essentially saying, don't follow up on the other leads. We're only focused on Jason Carter at this point. And Your Honor, that's 2 years before the arrest plus. Exhibit AG is an October 2015 email from Agent Ludwig to Sheriff Sandholt discussing a new report relating to the Followell's involvement and directing Sheriff Sandholt essentially to stop following up on the Followell leads without new information. Your Honor, again, if at this point there was not continued investigation into other leads, that prosecutorial delay is prejudicial to Jason Carter, who gets charged 2 years plus later and then has to try to follow up on leads that are more than 2 years old. Your Honor, this court saw the state put up the information from the depositions of Jason Carter. Those depositions took place at a point after the state had written a press release about arresting Jason Carter. Courtroom testimony was presented to this jury. All the while, this agent is commenting, while some of that testimony is going on, about the favor that's being done to the state's case by presenting this civil case. Your Honor, Exhibit AH, specifically, Agent Ludwig says the criminal case will be easier because of the civil trial, and I believe he uses the words, quote, "the perfect gift for us," unquote. And he specifically references things said within the courtroom during that time. Again, Exhibit AI is Agent Ludwig seeking testimony of Jason Carter from the civil trial. We discussed the testimony of Trooper Thorpe at this trial, that Agent Ludwig was keeping him up to date during the civil trial. And again, I would point out that Agent Ludwig was testifying as late as the 11th of December and was not released. Your Honor, the continued failure by the state to preserve information or to follow leads has prejudiced my client greatly. Exhibit AA, Detective Caius provides an email regarding deleted reports that he had provided to Agent Ludwig. And Your Honor, we know that there have been a number of lost reports, mislabeled reports, unfindable reports in this case. Exhibit AC, Todd Farber's information wasn't followed up. And I'm trying not to repeat myself, but some of these go both to the bias and the failure to follow up. Exhibit AL is a November 2018 email and attachment from Detective Caius to Agent Ludwig about the Charity Rush interview, in which she provides information that Joe Sedlak admitted to her his involvement in the murder. More information that wasn't provided to the defense. There was some information about Charity Roush, and much of this was discovered, but most of it through deposition. But this was prior, I mean, this is information that should have been shared with the defense. And then the one that just falls in line with finding a box full of exhibits, the Friday before trial, is Exhibit AM, which is a January 16th, 2018 email from Agent Ludwig indicating that numerous files, at least some of which were undisclosed, could not be copied and should just be noted as maintained by Marion County Sheriff's Office. Even though clearly when he's saying I can't open them, they're not maintained by the Marion County Sheriff's Office, and it appears his plan is just to do exactly what he did, which is throw them all in a box, wait until a month before trial, not disclose them to anyone, and throw them in the evidence room. This is such an egregious, it is just unbelievable, the amount of information that is not provided, not followed up on, not disclosed, and then you throw on top of that the absolute manipulation of the civil trial process in order to gain advantage in a criminal case. Your Honor, I think this now crosses the line to where actual prejudice and bias is clearly shown. Your Honor, there just is no other recovery available to Jason Carter in order to provide due process and fairness other than dismissal. And Your Honor, I can address our motion for judgment acquittal now or wait for the state's response on the renewed motion to dismiss.
Let's wait.
Okay.
Let me ask you this, Ms. Branstad. One of the arguments you seem to be making is that if the state has suspicions that someone has committed a criminal offense and there is civil litigation going on involving that suspect, that it is not appropriate for the state to simply wait to see if something is learned during the civil proceedings that will tip the scales one way or the other insofar as the charging decision is concerned. During the original hearing on the motion to dismiss, I asked Mr. Olson if he was aware of any case law that supported that legal proposition. Have you found any?
Your Honor, I'll address that in two parts. Your Honor, this isn't just that it's inappropriate ever to wait and see if additional information comes out of a case, but this is specifically intentionally delaying prosecution. It is prosecutorial delay in order to try and gain only inculpatory information. This isn't continued investigation to determine if the suspect should be arrested. It's just manipulating the process. In this case, the state only provided inculpatory evidence to civil litigants, and it appears sought to get that verdict of liability in order to bolster their case. The state shouldn't be on one side or another. This should have been continued investigation if that was warranted. But this appears that it was simply trying to manipulate a civil litigation in order to gain advantage in a criminal trial. That's not continued investigation. That's just unreasonable prosecutorial delay. And Your Honor, one of the things I pointed out previously is if you look at the minutes of testimony, there's not one bit of evidence that was collected during the course of that civil litigation. I mean, there may have been experts who were contacted, but there was no additional investigation. There was no additional evidence that came in. It was simply waiting to see if the civil trial could be used for an advantage.
I take it the answer to my question is no?
No.
Okay.
I have not found anything additional that is directly on point. It's the same law that we provided.
Okay. All right, Mr. Bowl, would you like to respond?
I would, Your Honor, and I was handed these statements literally 10 seconds before Ms. Branstad stood up to make her argument. So,
As was I.
but I will do my best. I want to focus primarily on what the state, or at least myself, as I stand before you off the cuff, would indicate seems to be an inconsistency with the defense's argument. The defense wants to say we didn't have any of this information. At the same time saying we're aware we don't have the information, but we don't wish to continue the trial. Secondly, they indicated that the only reason they have this information is because the state provided it to them. So if the issue is timing, that would have been cured by a continuance, which they specifically did not wish to have in this case. We got this information at the same time. As it relates to the email, make no mistake, Ms. Branstad and her defense team certainly could have filed a Freedom of Information Act request long ago to gather this information, and they chose not to. Instead, They waited until a week before the trial was to begin, filed a motion to compel, included in it requests for emails, and then the state literally dropped everything on the IT side of the state of Iowa and got them their documents. And then they turn around and say, we don't have these reports, but we didn't have them timely. They're included in the information that they're submitting.
Let me ask you a question, Mr. Bull.
Yes, sir.
It is my understanding that this information was in fact the emails that make up the bulk, if not all, of the exhibits that we have been handed were provided to the defendant on the evening of March 7.
I have no reason to disagree, and I know we tried to work backwards to figure that out. I don't disagree with that at all. I would just indicate.
No, you're the one that told me.
Right. So that's my best estimate, Judge.
Would you agree with that, Ms. Branstad?
Yes, Your Honor.
Okay. You may proceed. I'm sorry. I
No,
didn't mean
no.
to interrupt you.
Judge, there's really two issues that I think are involved. The first is somehow implying that a law enforcement officer who believes that a person is a suspect somehow is wrong by advancing that theory, that creates bias and tunnel vision. That's the argument we heard in opening statement, so I'll adopt it here. Where the contrary is, they still followed up on every lead. They interviewed all of these people. In fact, at some point, depending on how this case goes, I'm assuming that the 5 binders of reports the defense have given me as their exhibits that include every police report will be stacked up on this desk for closing arguments to point out the amount of work that law enforcement did in this case. They point out examples, Judge, and I'm just going to spitball a couple, where they say things like, Mr. Farver. And Mr. Farver says, John and Joe Falwell left their wallets at the scene. So if you take what Mr. Kennedy testified to, if you're doing a suspect or an evidence-based investigation, what you shouldn't do is drop everything and go talk to Mr. Farver. Because Mr. Farver clearly doesn't have accurate information about the case. Moreover, what the defense doesn't want to tell you is Mr. Farver's coming forward when he is currently pled guilty to sex-based crimes and is looking for downward departure in the federal court system. So now all of a sudden he wants to reach out to the defense about information. Unfortunately, his information isn't accurate. And that's the issue that we had with the fact that Mr. Gracious, the defense's private investigator, testified in federal court about it. So, Judge, that's one example. Secondly, they point out an email from Special Agent Ludwig to Sheriff Sandholt saying, hey, stop wasting your time on the Falwells. Well, that's a great paraphrase, but it's not what the email says. The email says, unless there's new information, I don't see any point of continuing to follow up. Those are two entirely different comments. But if we're, additionally, Your Honor, when I look at S&T, it is Special Agent Ludwig saying, if there is, in fact, because NBC has cameras in the courtroom, please preserve that evidence. We'd like to get a copy of it. What do we have to do to get a copy of it? I'm not certain why that's impermissible for him to want to obtain the evidence. That's exactly what the defense has been saying for 2 years. We want him to get all the evidence, except unless it implicates their client because he says things that are inconsistent with what he said before. Your Honor, additionally, as it relates to making the comment about Kurt Seddon that this is exculpatory and therefore Brady violation, I'm not certain that Kurt Seddon didn't testify, and I'd have to look at the transcript. He's not certain which one said it. That's what he testified to. I don't recall. So if I'm mistaken, we'll look at the transcript. It was who was primarily doing the conversation. He then indicated after he had an opportunity to think about it, reflect, understand who was standing where in that conversation. That came out. That testimony came out. He was deposed as well. So I'm not, Judge, when we start to talk about things that not provided and not discussed, the defense has the information that they have because it's been disclosed by the state of Iowa. Additionally, Your Honor, when they start talking about nothing else was done in this investigation during the time which the civil case was ongoing, it simply flies in the face of the exhibits and the evidence that they have. And I would point out the cell phone information I think is very valid. This is a case in which the state long ago believed that there could be an assertion that probable cause existed to arrest Jason Carter. That is a different standard than I or my colleagues having a good faith belief criminal conviction is likely to occur. which I believe is my ethical standard to advance a case. There's no point of arresting a man, having his picture show up on TV, having to have to post a bond to get out, if the state of Iowa does not believe that within 90 days it can bring the case to trial. And as was clear by the testimony that was presented in this case, the state has placed weight into Jason Carter's cell phone activity and where it was located. In the information that was primarily gathered through law enforcement, I was not confident in its outcome. I then began to seek out additional individuals who I believed had extensive background in this information. When I started to gather that information and learn things about cell phones that I didn't know before, I then started to dig further. We have all sorts of issues that I think we may hear from the defense, for example, about where people are located when their 911 call came in. The first time, by professional statement, I would indicate to the court, first time I heard that information, Judge, the information that the state of Iowa received is Jason Carter standing in the pig barn when he calls 911. It's only after we do additional, and I educate myself on the process, that I learn that there's a rebidding process during 911. If the call is not rebid, the accuracy is not accurate. That was a terrible use of word. It's not as accurate as it needs to be trustworthy. I don't know that information. I'm just getting GPS. I have to reach out. Judge, what I heard was not provided, not disclosed. They have it. If the issue is timing, the defense never filed a motion to compel. The state's the only person who timely filed a motion to compel to try to get the defense's witnesses in this case. When you finally ruled on the motion to compel, the state gave them the information as quickly as we possibly could, and we told them, Judge, the reality of this case is, if you print it out, it's 5, probably 4 ring binders. The amount of times that we've gone back and forth where the defense asserts it doesn't have a report, only to learn it's been given to them long before, is you can't count on 2 hands the number of times that's happened. So, Judge, we'll take our lumps. What I've just heard is grounds for cross-examination of a witness. You made up your mind early on. You didn't follow up on this lead. That's cross. That's not a motion ground for a motion to dismiss. Judge, I continue to maintain that what I wish and hope that in every single case, every time a person's interviewed, it's audio and video recorded, and that's immediately preserved and it's saved? Absolutely. If there's a person who's been prejudiced in this case by the state of Iowa not having that evidence, it's the people sitting at this table as it relates to John Thorpe. Where's the video evidence of John Thorpe's drive to Cargill and back? Now, for whatever reason, the defense didn't choose in cross-examination to ask Trooper Thorpe, where's the video of your drive? Because they learned in the deposition the answer was it never was preserved based on the old system that we had, so it was written over. For whatever reason, that wasn't their pocket on cross. I'd love to be able to have the video that shows how quickly Trooper Thorpe was accelerating and decelerating. I don't have it. That's a detriment to my case. That certainly doesn't affect the defense. It's to their advantage. Judge, there's a lot of stuff here. I concede that. Now, if it's inquiry between law enforcement officer and law enforcement officer to discuss strategy and theory and how we're going to place our resources, that's fine. But the mere fact that you drop a stack of information, the weight of it, doesn't in and of itself mean anything at all. We have to examine each document to try to figure out whether or not information is actually prejudiced the defendant. And for what I've heard is because arrest was originally considered in March of 2016, and because the state of Iowa said, meaning my office, I don't think you have it yet, dig deeper. Or because I say to law enforcement, I want you, Sheriff Sandholt, to appoint Deputy Caius to be the full-time person to run down all of these names. That somehow, that's not what we want. Imagine the contrast. We bring charges against a person, and then what do we hear? You didn't run down every lead. You rushed to judgment. You had tunnel vision. The alternative is when you take your time and you do an investigation, when law enforcement officers potentially disagree about what a lead means or how far we go, how far down the rabbit hole do you follow? I mean, it's Judge, it's the Greek, the gentleman who keeps rolling the ball up the hill only to get to the top to have it roll back down. At some point, law enforcement has to go with what they have. And based on the information that we had, when we had it, we without delay brought a charge. And because of the time in which it took, and the fact that this case did not go to trial quickly, the defense, with its substantial resources, continued to bring up individuals, and law enforcement continued to investigate them. That's exactly what we want law enforcement to do in the state of Iowa or anywhere in this country. Nothing further.
Mr. Bull, you know,
Yes,
I received the exhibits, there are maybe 100 pages of emails here, at the same time you did. Take a look at Exhibit AM.
A.M. as in Mary?
Yes. This is an email from Mark Ludwig a year ago, January 2018, more than a year ago. And he says, "The missing audio files are causing me problems. I'm working on them, but we might need to say, quote, maintained by Marion County Sheriff's Office, end quote, if I can't get them to copy over." What do you make of that?
Judge, I can tell you what I think I make of it, but I would like to have the ability to supplement my answer if what I'm about to tell you is not accurate. My understanding is each and every one of these statements, I think they're specifically to the audio, are WAV files or old-fashioned dictaphone files that existed at the time when you had not your cell phone, but you had the Canon machine. What I make of it, Judge, is Special Agent Ludwig is having a difficult time opening them and putting them into the format that's required by, I believe, a secretary at DPS who takes all this information and then loads it into a 2-disc set that then allows you to click on the hyperlink and then it plays the audio. Now, what I believe this to mean, although I would like to clarify, is the originals were being maintained by the Marion County Sheriff's Office. So if I can't get these to copy over, we might need to say maintained by Marion County Sheriff's Office because they had the original source file. I think that if you dislike Special Agent Ludwig or you believe somehow he's biased in this case, you read something else into it. But I also think it's just an accurate statement, and perhaps when one colleague is talking to another, we need to be mindful that a year and a half later, some defense attorney or prosecutor will look at it and try to read something else into it.
Ms. Branstad, are you advocating, expecting me to rule from the bench on this motion to dismiss based upon this newly provided information?
Only if you intend to rule for the defense, otherwise I'm sure it will take some time to review. And, Your Honor, I just want to point out, the state had these exhibits longer than we did. They were provided by the state. It took us a while to go through them, just as I'm sure the state has been busy, but, Your Honor, we had 80-plus discs dropped in our laps on March 1st, and then on March 8th, we had another however many hundred emails. Your Honor, I want to address a few things, though. First of all, attorneys for Jason Carter did a Freedom of Information Act request, but that's not available in an ongoing criminal case. It's denied until the criminal case has concluded. So these weren't available from that. And they certainly were requested, not as emails, but as the discovery request for exculpatory information or other information. And I would just want to go through just a couple of things. Kurt Sen did testify that he was certain that Jason Carter was the person who made that statement. He said he may not have been certain earlier, but he'd reviewed it and he was. Those notes may have been helpful either in impeachment or in finding out anyone else could provide a prior inconsistent statement. We don't have all of these reports, and when the state says a number of times the defense has asked for a report and we already had them, it isn't simply a matter of asking for a report by name and having it. we may ask for report 11-54 because we don't have 11-54, and then the state responds, oh, you have it, it's just Exhibit A in a different deposition, or you have it under a different name or under a different file. But this isn't a situation where we necessarily knew that A24 is the same as attachment B someplace else. There are thousands and thousands of pages, but in this case, we don't have the report of Angela Johnson. We don't have the report of Todd Farver from 2016. We don't have the reports that I have stated specifically. There are other reports that we're not sure if we have, but there are a number that we do not have. And then the question was, should the state have to reveal all the, I'm trying to remember exactly how it was phrased, but our answer is that the defense should know what the reports are so that they can either investigate them or cross-examine. And we just simply did not have all of this information. There are huge amounts of information that we don't have. And then I don't know that there's any other way to interpret when there's a new report in and Agent Ludwig says, don't follow up on it unless there's new information. Well, a new report is new information. In this case, the state's response was, well, you could have asked for a continuance. Delay is prejudice at a certain point, and we set this trial out quite a while in order to gain information, and it got, certainly there was a lot of preparation and a lot of things were done, and then more than a terabyte of information falls into our hands the Friday before trial, and the answer that the state gives is, well, resubpoena all your witnesses and just start over. There were reasons for not wanting to continue, and I don't think it's incumbent upon Jason Carter to accommodate the state's delay in providing information. And certainly Jason Carter did not know that we still didn't have all the information until after trial started. And now it's not even that we have all the information, we just know some of the information we don't have. This is a 4-year-old case. I mean, this case doesn't just date back to the date that charges were filed. This dates back to the date of Shirley Carter's death. I mean, it's almost 4 years old. And during this time, many of these reports are multiple years old. The state had every opportunity to provide these. With regard to Mr. Farver, at the time that he made the report, he was a citizen. It was before he was in custody. It was before he was charged, I believe.
Well, Ms. Branstad, I will tell you, I have no intention of ruling from the bench in favor of either party on this motion. I think it is appropriate, in light of the volume of materials that you have provided, to give Mr. Bull an opportunity to respond in writing and with exhibits if he sees fit, or to request an evidentiary hearing. But in any event, give him an opportunity to formulate a response to your renewed motion to dismiss. So I am going to officially take this under advisement and advise you, Mr. Bull, if you believe you need, well, I would ask that the state file a short pleading by Monday, advising me as to the amount of time that will be needed or at least requested to respond to the renewed motion to dismiss with the renewed exhibits that have been provided to me. And if you can have that on file by the end of the day on Monday, I would appreciate it. What that means, Ms. Branstad, is we are in the middle of a trial. And it needs to move forward, and it'll be up to you and the other attorneys representing Mr. Carter how it moves forward.
Unless Your Honor grants our motion for judgment of acquittal.
Yes, you're
Which-
exactly right.
Your Honor, may I make one additional comment as it relates to Mr. Seddon's document, or the document I'm referring to as the Seddon document?
You may.
Your Honor, as I look through these notes, I just want to be clear. As I look through these, and I am not a handwriting expert, these are the deputy's notes. This isn't Kurt Seddon. If you look, when you look at each person, the fact that it's on the same page and the way that Jason is spelled, the way the loops are, this is Jake Smith's notes of the interviews that he conducted on the scene. And to that end, the defense was given the audio and given a report of Jake Smith's work on this case as it relates to this document. So to sit here and say you weren't given the police officer's original notes, I'm not sure that's the standard, Judge. I think this is law enforcement's notes and then additional notes of other potential cars and the like. So to the extent that we're talking about this document, which is V for the record, the defense had Jake Smith, the audio of his interviews and his written report. It appears to me these are merely his notes of those interviews, because I see no reason why any of those lay people, the last page that includes license plates, numbers, and other things would have existed.
And that's why I'm going to give you an opportunity to respond, Mr. Bull. On behalf of the defendant, anything further?
Your Honor, at this time, the defendant moves for a judgment of acquittal. In reality, there really is not sufficient evidence, even taking reasonable inferences in favor of the state, to find Jason Carter guilty in this case. The state read the trial information stating that it was a willful, deliberate, and premeditated murder of Shirley Carter. And at this point, Your Honor, the state has provided a lot of information that Shirley Carter was shot and killed. But the only evidence that I can come up with implicating Jason Carter are statements he made that are questionable speculation as to what occurred, information about a gun that may be the murder weapon, that was in the house at some point prior to June 19th, 2015, with no specific time as to when that weapon had last been in the house, and some questions as to whether Jason Carter had opportunity. And Your Honor, I will point out that the state does not place the time of death at any point when Jason Carter would have been in the home. They just question whether it was earlier. But there is certainly nothing establishing motive, anything other than a small opportunity that is questionably within the time of death. But there is no evidence. There is no forensic evidence implicating Jason Carter. There is no direct evidence. The only circumstantial evidence of any sort are some statements by Jason Carter that are mixed in with a number of other statements that are speculation about a gun that isn't established as the murder weapon, is just established as a possible murder weapon. There is some evidence that Jason Carter may have moved some distance without any limits on it outside of the direction that some statements say he did, although Jason Carter, in the statements that were played, indicates that he went to the bottom of the driveway. And there is just no other implication. And Your Honor, there has to be some evidence, some of malice aforethought. There has to be some evidence of actually committing the shooting. There has to be something more than just really very tenuous speculation based on a very thin thread of evidence. Even if the reasonable inferences, and they have to be reasonable, are made in favor of the state, there is nothing that indicates that Jason Carter was responsible for the death of Shirley Carter other than opportunity. And opportunity is even a little bit questionable here. That's it. It is such a thin line of evidence that, again, even with all reasonable inferences, and I can't stress reasonable enough, there is insufficient evidence upon which a reasonable fact finder could find that Jason Carter shot Shirley Carter, or that there was malice aforethought, or of any willful, deliberate, or premeditated act or specific intent to kill Shirley Carter. These are the three elements, and none of them is supported by significant evidence. Enough evidence to convict. Truly, all the evidence provides that Shirley Carter was in fact shot and killed, but none of the evidence provides a strong enough showing, even with all inferences in favor of the state, of any individual as the shooter.
Mr. Bull?
The state respectfully disagrees, Your Honor, taking the evidence in the light most favorable to the state. The state has generated a prima facie case and a jury question on the issue of murder in the first degree against Jason Carter. The state has established venue and identification of the defendant. The jury could reach the...
I'm sorry, Mr. Bo, I'm really getting tired, so slow down a little bit.
Yes, ma'am.
The state has established
Venue and identification of the defendant. The jury could reach the conclusion that on June 19, 2015, Jason Carter arrived at 132 Perry Street sometime between 11:50 and 11:08 a.m. The evidence is found from both John Thorpe's testimony and Bill Carter's testimony considering the time in which it takes to make that route or drive that route. Additionally, Your Honor, we believe the jury could establish that Jason Carter left Casey's in Pleasantville, Iowa, which is north of where he keeps his semi, sometime after 8:02 a.m. and arrived there sometime before 9 a.m. based on his testimony. So the jury could reach the conclusion of how long it took Jason Carter to drive to Eddyville that morning with a loaded semi, coupling that with the information concerning Bill Carter's testimony that an unloaded semi takes less time than a loaded semi. The jury could conclude that after Jason Carter called 911, that he approximately had 10 or more minutes prior to anyone else arriving on the scene. That's contained in States Exhibit 11 and 12. Your Honor, I don't believe it's disputed that Shirley Carter was killed after being shot with 2 bullets, and the evidence before it is that that was a high-powered rifle. We also heard that the bullet used was consistent with or with a .270 round, according to Vic Murillo. He also establishes that the weight of those bullets establish it being a .270. Your Honor, the evidence has established that only 3 things are missing from the crime scene, that being the bolt-action .270 Remington rifle, that being the spent shell casings, and that being the jersey gloves. Your Honor, Jason Carter did provide statements at the crime scene that only an individual who committed this offense would know, besides, of course, the person who was killed. Jason Carter knew his mother had been shot. Jason Carter knew his mother had been shot in the side That was offered by the defense in their exhibit of James Lane, video camera, audio, but showing video as well. That's important, at least from the state's perspective, because by all other accounts, the only visible injury was a small hole in the center of her chest, as identified by Ms. Goff and James Lane. Jason Carter, by his statements, Your Honor, knew that his mother had been shot with a firearm and asserted it was during a burglary, knew that the shooter took the gun with him, and Jason Carter asked his brother, and a jury could conclude, that whoever committed this offense would have had to rack another round. Jason Carter stated that the zerts were greased to Brad Kaufman when they were not. Additionally, by all evidence on the record at this moment in time, Jason Carter has continuously maintained he was only in 2 locations in the home, that being the basement and the kitchen. The jury could conclude, in addition to that, according to statements made today, played in 143, Jason Carter further stated that he had no knowledge after his father returned from the bedroom as to if the bedroom had been ransacked. As such, the statement to Brad Kaufman that Jason Carter knew his parents' bedroom had the drawers pulled out, in and of itself would be the only information that the shooter would know. Your Honor, further, the jury has heard evidence that places Jason Carter's cell phone north and east of the property, which is not consistent with any location Jason Carter has ever maintained he went. Moreover, notwithstanding the arguments of the defense concerning that he went to the driveway and by the tree and waved down the ambulance, the jury, from reviewing the information from Mr. Valencius, as well as examining the cell phones and the state's exhibit concerning those maps, would find that at each and every time Mr. Carter made the phone calls, as enumerated in the exhibit, Your Honor, I don't have it in front of me, but the blow-up of the calls made, every one of those phone calls is bouncing off one of the 2 towers that provide primary coverage for 132 Perry Street. So when he's calling the sheriff and he's outside, he's off 1 or 2 of the towers. When he's going down to see if the ambulance goes by, he's off 1 or 2 of the primary towers. It's only during the 3 minutes where Jason Carter is unaccounted for that he is not on one of the 2 counters. Additionally, Your Honor, the jury could further conclude that Jason Carter had opportunity by way of a 4-wheeler purchased by Jason Carter and his wife, for Bill Carter. We do notice that there are 2 receipts for gasoline that morning. One to fill what appears to be to fill up his pickup, the other to fill up a 2-gallon bucket or gas can. We also see in that photograph, the jury can conclude that is not a natural resting location when that truck pulls into the driveway based on where it is. So, Your Honor, with all of that in mind, further, the evidence does establish that the .270 was in the safe. There's no evidence to assert that it was anywhere else. Jason Carter specifically states we need to go downstairs to see if one of your rifles went off. The testimony that we have indicates that is the high-powered rifle in question. As such, we have generated a question as it relates to malice aforethought. We have the use of a weapon. Secondly, Your Honor, the evidence will establish that a person and the jury taking the evidence, sorry, Deb, in the light most favorable to the state, could establish that the person would have had to enter that home. The evidence would further reveal that the person attempted to load that weapon, dropped a bullet, perhaps because they're wearing gloves, then went to another room in the home to get to in the laundry room, then came back upstairs and then fired a second shot. Your Honor, if the defense is conceding someone committed murder in the first degree, which is the way Ms. Branstad ended, there's certainly sufficient evidence for this matter to go forward to the jury, as we've established that person is Jason Carter. Thank you.
Thank you, Mr. Bull. In ruling on a motion for directed verdict at the close of the state's case, I am obligated to view the evidence in a light most favorable to the state. A jury passing judgment on the evidence presented during a criminal case is allowed to consider both direct and circumstantial evidence. Our law makes no distinction between those 2 types of evidence. In this case, it is incumbent upon the state to prove beyond a reasonable doubt that the defendant shot Shirley Carter, that she died as a result of that gunshot, that in doing so, the defendant acted with malice aforethought, that he acted willfully, deliberately, premeditatively, and with a specific intent to kill Shirley Carter. Viewed in a light most favorable to the state, a reasonable juror could make a conclusion in favor of the state as to each of those elements of this offense. Accordingly, the defendant's motion for judgment of acquittal, directed verdict is overruled. I would like counsel to be available 8 a.m. Monday morning in the event there's anything we need to take up before the jury comes back at 9 a.m. Okay? This week.